everyone, my name is Vaishnavi Parate. I am a law student and today we are going to discuss and learn about what is the doctrine of Casus Omissus. So let's start. Let's start with the introduction. The doctrine of Casus Omissus outlines the circumstances where a court can supply an unintended omission by the legislature in drafting a particular provision. This issue arises quite frequently and in varying circumstances. There have been several recent and conflicting decisions on this point. Now let's see the meaning of this doctrine. Doctrine of Casus Omissus means if a particular case is omitted from the term of the statute, though such a case is within the obvious purpose of the statute and the omission appears to have been done by accident or inadvertence, the court cannot include the omitted case by supplying the omission. Casus Omissus thus reflects the age-old tussle between the courts and the legislature. This is because the courts are not inclined to interfere when a Casus Omissus is revealed by the legislature. Now let's see the origin of this doctrine. Casus Omissus finds its origin in the Latin maxim Casus omissus pro omisso habendus est, which means that a case omitted is to be held as intentionally omitted. Casus Omissus also reflects the age-old tussle between the courts and the legislature. Now let's see the application of this doctrine. The principle of Casus Omissus is a tool of statutory interpretation. Casus Omissus may arise when a statute makes specific provisions regarding several enumerated cases or objects but omits to make any provision for a case or object which is either analogous or similar or identical to those already enumerated. Such a case or object or situation may have been omitted by inadvertence or because it was overlooked or unforeseen. Now let's see the changing nature with the changing time of this doctrine. The courts have shifted their approach, leaning in favor of interfering in a limited manner in the instance of Casus Omissus. The trend was gradually shifted to the adoption of equitable construction where something is absent in the text of a statute, and it is presumed in such situations that the case or object that is absent in the text of the statute could be read into that statute by way of necessary implication. Now let's see modern day meaning of this doctrine. All the above stated words of wisdom must be understood with a caveat that a court should not so interpret a statute as to create a Casus Omissus when there is none. The courts need to tread cautiously in this regard. Nevertheless, it could be safely stated that in the modern day, Casus Omissus is understood as a situation not provided for by a statute or a contract and therefore governed by case law or new judgment law.